Hey everybody, Benjamin Keck with Keck Legal. Today I want to talk a little bit about Article 9 sales. What is an Article 9 sale? Perhaps you've found some information, some videos, some people talking about Article 9 sales for your business potentially. Let's talk about what that is, what it means, what the ramifications are. When we've got a company that's in financial distress, there's lots of potential ways of dealing with that. You could have an Article 9 sale, we could have a receivership, you could have a Chapter 11 filing, you could have a Chapter 7 liquidation, lots of different potential avenues. So I've seen some consultants out there who are basically promoting Article 9 sales that, oh, this is the solution, this is the way to go, this is the best thing to deal with the financial distress with your business. So let's talk about what is an Article 9 sale, what it actually can accomplish. So an Article 9 sale is a foreclosure. It is the lender foreclosing on your assets. So if you've got real estate, every state has different laws for how a lender can go about foreclosing on your house or whatever real estate you're dealing with. Now, when we're talking about other types of assets, other non-real estate assets, what we in the law call personal property, is anything that's not real estate. The way that's typically dealt with is under Article 9 of the Universal Commercial Code, the UCC. So the UCC is uniform laws adopted across all the states so that the laws don't change from state to state. It helps promote commerce and gives some certainty to the economy that, okay, here's our laws are going to be consistent no matter what state you're in. When we're dealing with certain things like liens and creditors' rights and certain other things as well. So Article 9 specifically deals with liens, and so it deals with all the different things related to lenders and people who might have liens on certain assets and how all of that works. So when we talk about an Article 9 sale, we're talking about a lender foreclosing on the assets, which kind of similar to a foreclosure sale of a house, for example. Here in Georgia, they go up on the courthouse steps and auction off the house, and somebody can then buy that house. So Article 9 sale kind of works the same way. They put out a notice, hey, anybody that wants to buy these assets of the business that we, the lender, have a lien on, we're going to have a sale and there's going to be a deadline for you to buy those assets. And sometimes this can be a way to allow the business to survive. If you have perhaps a friendly buyer who's willing to buy these assets in an Article 9 sale, then maybe it might make sense to cooperate with the bank and say, hey, we want to have a cooperative Article 9 sale where you foreclose and sell to this buyer that we've found for you, bank. And by the way, the buyer has to pay the money to the bank to buy probably all of the assets of the business. Typically we see this in the situation where maybe you have an SBA loan where the lender has a lien on basically all of the assets of the business. Maybe there's some exceptions for some vehicles or things like that, but let's just assume it's most all of the assets being sold to this buyer. So maybe you've got a friendly buyer who's willing to pay a reasonable price to buy the whole company, and then that money goes to the bank. Now, a few issues with that. One, that's usually a short sale situation, right? Usually the bank's not getting paid in full, which means if this is an SBA loan that you've personally guaranteed, well, guess what? That bank still owed all the money. So let's say banks owed $1.3 million and you get an Article 9 sale done for $300,000 and sell the company. Now the buyer owns what used to be your company. You no longer own any of these assets. Buyer owns the company now, owns all the assets of the company. Your company has nothing, it's gone, you sold everything. But you only paid down $300,000 of the $1.3 million. Now the bank's going to come back and say, well, what about our other $1 million, right? And if you've personally guaranteed that, the bank is, unless they agreed to release the personal guarantee as part of the deal, then they can continue pursuing you personally on that $1 million. If there's other assets that have been pledged, have did you give them a lien on your home? Guess what? They're going to now try to foreclose on your home. And I saw this, you have a client did an Article 9 sale, sold, assets of the company to, a friendly buyer. And the bank said, thank you very much, we're now going to foreclose on your house. So wound up having to file a personal Chapter 11 case for that individual to save his house and try to work through that. So I do get a little concerned when I have seen some consultants out there saying, oh, Article 9 sale is the way to go, and I've even seen one that says it's like an alternative to Chapter 11, and you can avoid Chapter 11 by doing an Article 9 sale, it's a very kind of a bizarre thing to me. Why would you want to avoid Chapter 11 protection and instead choose to get foreclosed on? That doesn't make a whole lot of sense to me. So I think some people have this, when they hear the B word, when they hear bankruptcy, they think that that's the worst thing in the world. Actually, it's for your protection. Like it's in the Constitution that we can have bankruptcy laws to protect you. So when I see consultants out there talking about avoiding bankruptcy like it's a bad thing, that's a red flag. You should definitely know what all of your options are. There may be some situations where an Article 9 sale might make sense, but you need to know what all the repercussions are. You need to know, okay, this isn't the end of it. Okay, we agreed to this Article 9 sale, sold the company, you don't own that company anymore, it's been sold now. If it didn't pay the debt in full, the bank may continue to pursue other collateral, personal guarantees, things like that. And you've got to weigh that against other potential options of, okay, what if we look at a Chapter 11 filing to save the company instead of getting it foreclosed on? What if we try to sell the company through Chapter 11? What if we just shut down? What do all these things look like? So you definitely need to be talking to an attorney. If this is anything, under no circumstances, if you're talking to a consultant that's suggesting Article 9, you need to pump the brakes and talk to a lawyer. Now, there's some situations where Article 9 might make sense. In my experience, those situations are rare. Usually it's not in the company owner's best interest to agree to an Article 9 sale. So be careful. If you are looking at an Article 9 sale, make sure you understand all of these things and make sure you understand what all of your options are. And I would definitely recommend talking to an attorney if this is something you're even thinking about. If you are here in Georgia, definitely feel free to reach out to Keck Legal. That's www.kecklegal.com. Happy to help. Thanks, everybody.